We want you to go take ETG, see if you got any alcohol in your system.
This case opens with immediate tension, and it's not subtle. Right out of the gate, the court is dealing with potential alcohol consumption, something that may seem minor on the surface but carries serious legal implications, especially when bond conditions are involved. An ETG test, which detects alcohol use over a longer window, isn't ordered casually. It signals that the judge has already seen something, likely social media posts or behavior, that raises red flags about compliance. What makes this moment powerful is the contrast between the defendant's denial and the judge's skepticism. Courts don't operate on assumptions, they operate on patterns. And when a judge references postings, that means there's documented behavior influencing the court's trust level. Trust is everything in pretrial conditions. Lose that, watch and restrictions tighten instantly. At the same time, the legal mechanics are unfolding fast. Adjournments, scheduling conflicts, and procedural clarifications. But underneath all that, the real story is control. The court is quietly establishing authority, setting boundaries, and signaling that any deviation, even perceived, will have consequences. This isn't just about alcohol, it's about credibility. And right now, that credibility is already under pressure.
All right. In essence, you're seeking an adjournment of these.
No, we're setting preliminary exam.
All right.
Hold on, just relax.
People would have their witnesses available tonight.
Tonight?
Preliminary examination in this matter will be set in person September 9th, 2000.
I'm sorry to interrupt you, but I have probate matters, 3 evidentiary hearings starting at 9 o'clock. I don't know how long they're going to go in probate court. It's over money issues. I think they're going to be long hearings. Can we go out? Is it possible?
Doing the 9th.
Yeah, I'd like to tell you I can't do the 9th. You're going to be going when?
To the 8th,
30th.
30th of August is fine.
No.
Of September?
Yes, sir.
I'm sure that's fine.
September 30th, 2025. That's at 12 noon. That is before me.
You're going to go test. You're going to do that.
What I'm going to do is I'm going to order that the defendant go over today. Ma'am, if I give you an ETG, there's some postings that indicate that you're consuming alcohol.
I'm not.
Probably shouldn't post in the fashion those are posted. You need to go over, take an ETG test. I'm also going to order that the defendant is to be placed on a sober link unit pending further order of the court. Her bond will continue. However, with those in place, I will then allow the defendant to travel to Kansas City September 3rd through the 8th.
Yeah, Judge, the tether will be removed and sober link in place.
What gave you that impression?
Nothing really. I was asking.
Okay. Oh, that was a question?
I was asking.
That'd be a no.
The tether stays?
Tether stays.
Okay. Thank you for your consideration.
Yeah, I understand the disappointment, but she also left the state without permission, seeming not to understand that order, do not leave the state of Michigan.
This is where the judge lays out the reality bluntly. Leaving the state without permission is not a technicality. It's a direct violation of court orders. And in most cases, that alone could justify immediate custody. The fact that the judge explicitly says she's lucky not to be jailed is critical. That's not casual language. It's a warning. From a legal standpoint, bond conditions are not suggestions. They are enforceable directives. When a defendant crosses state lines without approval, it signals unpredictability. And unpredictability is exactly what courts try to eliminate. But what's even more interesting here is judicial discretion. The judge admits he chose not to jail her. That tells you he's giving an opportunity, a second chance. However, that opportunity comes with increased control. SoberLink, testing, and closer scrutiny. Nah, this is a turning point. The defendant is no longer in a neutral position. She's now under heightened observation. Every move from here forward will be judged more strictly. The tone here also shifts. The judge isn't angry, he's firm. Controlled authority. And that's often more dangerous for a defendant because it means decisions are calculated, not emotional. At this stage, the message is clear. One more mistake and the outcome could be very different.
And I did not throw her in solely because of that. So she's lucky to be out and lucky that her only consequence of that has been a TED. Anything else?
No, Your Honor. Was she
These things
supposed to report back today after the
No,
testing?
she doesn't need to report back today. She needs to go over and take the ETG test. Well, there'll be an order over there, and she needs to pick up her sober.
Mr. McLean, who's approaching. Could you state your name for the court?
Michael McCartney.
Your Honor, in this case, I am respectfully requesting that it be set for preliminary examination. My information is I don't think there's any outstanding discovery.
People have their witnesses available to second.
We'll do our best, Your Honor.
And
Preliminary examination in this matter will be set September 2nd, 2025, 9 a.m. That is before Judge Freshour.
thank you, Your Honor. May I respond briefly? My understanding is this is the only case that is holding my client. He does indicate that he has an alternate place to stay besides with the complaining witness. The date on this complaint is from June 1st. I don't believe there's any allegations of any like bond violations or contact. This was a delayed arrest. So Mr. McLean wasn't arrested at the time of the offense. He was actually in treatment, and then he was completed the first phase of treatment, was out, was not having contact with her, and then was arrested. So I think that shows that he can be out of custody and stay away from her, not have contact with her as he was for at least a few weeks before his arrest.
Your Honor,
Ms. Zender, yes.
I would be objecting to any modification of bond. The facts of this case are that he was released from jail on 5/28/25 and immediately went to her residence after being released. He was formally served on that date. And then on the preceding days afterwards, he was on her property, hiding on her property when she would come outside.
Now the courtroom dynamic shifts into conflict. The prosecution steps in aggressively, laying out a detailed narrative that paints the defendant as a continuing threat. This isn't just about past behavior, it's about pattern and escalation. Notice how specific the allegations are. Returning to the victim's property, hiding, confronting, calling repeatedly. These are not vague claims. They're structured to show intent and persistence. In legal terms, this strengthens the argument that the defendant poses a risk to the complaining witness. Then comes the criminal history. Prior home invasion, dismissed charges, current domestic violence hold. Each detail builds a layered argument. Prosecutors don't just present facts, they build a narrative of risk. And here, that narrative is clear. This is someone who doesn't respect boundaries. What makes this moment intense is the clash of interpretations. The defense argues timing and lack of awareness. The prosecution argues repeated violation after notice. That distinction is everything. If the court believes the prosecution, the defendant looks defiant. If it believes the defense, it looks like misunderstanding. But courts often lean toward caution when safety is involved. And when you combine alleged violations with a criminal history, the scale starts tipping heavily in one direction. This is no longer about a single incident. It's about trust versus threat. And right now, trust is losing.
He jumped out and yelled, "Who do you have in your residence?" He then left and then began leaving her voicemails and calling her. A friend also saw him on her property. So I had concerns given that. I also have concerns given that of his criminal history. He has a previous home invasion first conviction from 2007 and 2022 dismissed home invasion first, a 25 dismissed PDHD second, and malicious destruction of a building. And he currently does have a hold outstanding for a domestic violence case with bond set at $500. So at this point, I would have concerns for her safety and communities, and I would ask that bond remain as set.
May I respond briefly?
Sure.
He was released from jail, but there was no contact order at the time he went back to her address. So I just want to clarify, it sounded really bad the way
Yes,
the
it
APA.
You were being zended. Go ahead.
He was not aware of and not served the PPO until afterwards. So it wasn't like he went to her residence after being out of jail and being told to stay away from her.
So he got arrested on what?
If I can clarify, I'm not sure exactly what's arrested. If I can clarify, he went to the residence on 5/28, was served the PPO that day, and then in the preceding days after he was served the PPO and told he should not be having contact, he went back to her property and then was also calling her. So he was violating that PTO after it had been served and he had been given notice.
Your Honor, he does dispute the timing of that. Obviously, I know this court this is not a hearing date, so I know we can't get into the details. The missed call login discovery shows 5:28 and not after. So we dispute that he made any contact with her after being served the PTO, but obviously that's the purpose of the exam. And so I just wanted to note that.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
The ruling comes quickly and decisively. Bond reduction denied. No hesitation, no extended reasoning. That in itself tells you how the judge views the situation. In legal practice, when a judge denies a motion this directly, it usually means the arguments against it were significantly stronger. The prosecution's concerns about safety, combined with disputed violations, created enough doubt to justify maintaining strict conditions. From the defendant's perspective, this is a major setback. Bond reduction isn't just about convenience, it's about freedom and leverage. A lower bond can change everything: ability to prepare a defense, maintain employment, stabilize life. Losing that opportunity keeps the defendant in a more restricted position. What's also important here is timing. The defense emphasized that this wasn't a full evidentiary hearing. That means the judge is making decisions based on limited information, but still chose to deny relief. That suggests the available facts were already concerning enough. This moment reinforces a key principle in court. Perception matters as much as proof in early stages. If the court perceives risk, it will act conservatively. And right now, the court is clearly choosing caution over leniency.
Good morning, Your Honor. Kerma Dadish on behalf of Mr. Patterson.
Good morning.
Good morning.
I've seen you walking around. You haven't said anything all morning.
Well, you'll hear me 4 more times. Hopefully.
Oh, that's a threat. Go ahead.
Say your name for the record, please.
Glad to say. Thank you.
Your Honor, I have submitted a green sheet. We are going to adjourn for mitigation purposes, and whenever there's a chance to address bond, please.
All right. Probably, well, the 4th gave you enough time to get something?
I would, if you could, the 11th, that's probably better. It's more time for our mitigation department.
So all she had to do was say no. September 11th.
Thank you, Your Honor.
2025, 9 a.m. But as to bond.
Your Honor, Mr. Patterson is charged with an Arno from 2022. He did fail to appear his last court date.
Well, 3 of them.
Yes.
Yeah, go ahead.
But since 2022, he has had no other cases. He hasn't picked up any new charges. He's been working. He has 10 kids now, 7 of whom...
Excuse me?
Sorry?
What did you say?
I said he has 10 kids now, 7 of whom are in his care.
This section introduces a completely different dynamic: humanization. The defense is trying to shift the narrative from criminal history to personal responsibility. 10 children, 7 in his care, stable job. These are not random details. They're strategic. In bond hearings, defense attorneys often highlight stability factors: family ties, employment, lack of recent offenses. The goal is to show the defendant has something to lose and a reason to comply. But the judge's reaction, getting stuck on 10, adds a subtle layer of skepticism. It's almost a moment of disbelief, and it changes the tone. Instead of strengthening the argument, it briefly disrupts it. Then the defendant speaks, admitting past mistakes and claiming readiness to face consequences. That kind of acknowledgement can help, but only if it aligns with behavior. Courts value accountability, but they also look for consistency. The issue here is timing again. The failure to appear dates back to 2022, but the arrest happened later under unrelated circumstances. That creates a perception that the defendant avoided responsibility until forced. So while the defense builds a narrative of reform, the prosecution and likely the judge are weighing that against years of non-compliance. This becomes a battle between who the defendant says he is now and what his actions have shown over time.
What? You want me to continue or stop?
No, I'm stuck on 10, but go ahead.
Okay. He takes care of 7 of them financially. He's gotten himself a job. He works in landscaping and home improvement. He's been at his job for a year. He sincerely apologizes for not appearing 2022. He's told me that it was a dumb mistake that he didn't. He was immature at the time. He was trying to run away from his problems, but since then he wants to get his life back on track. He's already done so by not picking up new charges and by having a stable job. And he wanted to say something himself as well.
I just want to say, being immature, I was running from my problems. I didn't want to go to jail at the time, but now I'm ready to face my problems and get my warrants out the way so I can raise my family and have a clean slate.
How did he come into custody?
Traffic stop?
At the room, police contact.
What happened?
At the room at Days Inn with my friend. She had the room for her foster care son. He had did something. So they had both rooms and they came and knocked on
Hold on a second. So you came into custody not because you walked in
From 2022.
He did not.
And he's at the Days Inn.
No, it was just passing because her son was in foster care, but she had the room. They was
You
paying.
were at the Days Inn when you got picked up?
Yeah, when they came to the room, yeah.
They came to the
To
room.
the room for her son doing something. And
Police contact that is
Police contact.
unrelated to him.
Unrelated to me. Yeah.
He
I didn't catch no charge.
And we did talk about him. He should have turned himself in since
I
then.
said it, yeah.
Yeah, you were. Yeah, it was a big skip. But okay.
But, if your honor releases him on his own personal recognizance,
They
will come every single time.
2028 if his pattern holds.
there will be no pattern.
No, that's all. So.
Okay. Ms. Zender would like to speak. Ms. Zender.
I would object to any modification bond. As the court has pointed out, he did fail to appear in 2022. He also has other holds are set for a 1482 case for an OWI that's up on September 12th. That's a $100 bond. Then a DV out of 14B that's up on September 15th with a $100 bond. In this case, there are 3 RNOs. And when officers went to arrest the defendant on the warrants that he had at the time, he was pulling away, not listening, was taken to the ground, had to be tased, and still continued to pull away. And then he also, when they had to get him to the car, he went dead weight and had to be carried. So I'd be objecting to any modification bond as well as with his criminal history. He's got 2 cleanings that he was convicted of, a DVSC he had a conviction on, a DV second, an unlawful driving away, and an OWI. So given the fact that he failed to appear for 3 years and had to get picked up, and then the facts of this case, I would object to any modification of bond at this time.
Can I briefly respond, Your Honor?
Give it your best shot.
All of these charges and his past history is from 3 years ago. The 2 cases that he has are $100 cash bond that convert to PR once he's released on this case. So he did PR on those. But all these allegations are from 2022. His criminal history is past that. Again, nothing since 2022. Those other cases, I believe those are also from 2022. So they're not new.
The only reason they're from 2022 is because he didn't turn himself in for failing to appear.
I did say nothing new from 2022, after 2022 since then.
Well, there's new things. He just hasn't
Appeared.
appeared on those either.
Well,
2 other courts.
they're from 2022. He hasn't appeared on them, but no new charges from
Because he
2022.
doesn't seem to want to go to court.
No,
I do have some
Now he does.
concern that he's
I do
at
wanna
the
go to
Days
court.
Inn, gets picked up at the Days Inn.
no, it wasn't that. But you guys just hear me out. Can you hear me?
Okay, sure.
I'm saying I was standing up at the room with my friend. She got a foster son that they was paying for the room. They did something, whatever. That's how I ended up getting picked up. So I didn't turn myself in. Yeah, I understand that.
Yeah, that's the point.
Yeah.
One more chance, Your Honor.
Okay, I'll show up to court home for 5 minutes. Something.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you.
The final ruling closes the door on leniency. Bond reduction denied again, reinforcing the court's consistent position throughout the hearing. Looking at the full picture, the judge's decisions follow a clear pattern. Prioritize safety, enforce accountability, and avoid unnecessary risk. Across multiple defendants, the same principle applies. Past behavior, compliance history, and perceived threat level drive the outcome. In this case, the defendant's argument centered on change. No new charges, stable work, family responsibilities. But the prosecution's counter was stronger. Failure to appear, resistance during arrest, multiple active cases. When those factors are combined, they outweigh personal progress in the court's eyes. This highlights a critical reality of the legal system. Rehabilitation claims must be supported by consistent action over time. One or two positive factors aren't enough when there's a pattern of avoidance or non-compliance. From start to finish, this hearing was about control versus credibility. And in both cases presented, the court leaned toward control. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.